Hi, my name is Robin Bell and I'm talking to you today about law and ethics for nurses and midwives. This is part of Foundations of Professional Practice 1B in NURS 1201. So what I'd like to start with today is just going through what we're going to talk about initially, and that is primarily starting off first of all talking about the difference between law and ethics, because they're not the same thing, but it's very important we differentiate between two. Both are important to our practice. Then I'll talk to you about professional practice, accountability, the regulatory framework in which we practice in the community, particularly in New South Wales. Then we'll talk about lawful practice and what the normal lawful requirements are of our practice we're most likely to experience in the workplace. Then we'll talk a little bit about negligence, just enough to give you a good solid foundation in how to avoid getting sued. Then we'll talk about consent, probably one of the more important areas of practice that we should be looking at in our capacity as nurses. And then some of the serious offences that I hope none of you ever have to experience in your time practicing as a registered nurse. So we'll start off first of all in this segment with law and ethics. So, law and ethics, two different things? Absolutely, always. And it's important that we understand the difference between the two, because while laws historically have been derived from ethical principles, they don't always end up being the same thing. They don't end up having the same effect, and they certainly aren't applied equally or in the same ways in our community. So, ethics, what are they? Well, perhaps it's a little bit easier to say what ethics aren't. Ethics are not laws. That's very clear. Ethics are not religion, although some religions do have laws and do have ethical principles. Ethics are not policies. So the policies that are made by hospitals and are made by Department of Health are not ethics. Ethics are not morality. Morality is more of an everyday sense of how we should act and how we shouldn't. Ethics are not manners, and I'm a big supporter of good manners. Ethics are not gut feelings, and I'm also a good supporter of gut feelings. So what are ethics? Well, ethics is the study of what we ought to do, of the things that we ought to do, of what we should do. It's a study of right and wrong. But right and wrong isn't necessarily the same for everybody or for every part of the community. It varies, and it varies quite remarkably. So if we look at ethics and right and wrong, there are actually multiple schools of thought. I'm not going to go through all of these, but what I will do is just explain one or two of them to you. Right? There's consequentialism, and that is that the end justifies the means. So it doesn't matter how you get there. It's a little bit like some of the political parties we have today. As long as you get there in the end, it doesn't matter what you do. There's deontology, famous from Kant, in which the motives and actions must also be right. So it's not just getting to the good result, it's actually what you do to get there that's also important. And then there's also schools like feminism, which is a gendered approach to moral philosophy that looks more closely at how gender affects right and wrong and what right and wrongs exist in the community because of gender. Now these are just three small examples. There's as many different examples as there are people who think about it, but it gives you an idea that ethics aren't fixed. They vary between individuals or between communities, and we have to take on board that ethics may change between different people that we experience in our practice. However, as we practice as nurses, we will be expected to maintain an ethical standard. Now, the ethics is not law. We'll also be expected to maintain a legal standard. So what is the difference then between laws and ethics? Because we have a fair idea now what ethics are. So let's have a look and see if we can understand the difference between laws and ethics. First of all, laws are required behaviours. They're musts. Okay? You mustn't exceed the speed limit. You mustn't kill people. You mustn't steal property. Okay? So they're musts. But ethics are expected. They're not necessarily enforced. It's expected that you should act in a certain way, but they're not musts. Laws, usually written formal documents. And this is part of laws being available for everybody so they can be fairly applied. So they're written down, they're codified. But ethics are usually unwritten principles. Even if they start as unwritten principles, they may end up being codified in certain expected ethic behaviour patterns, but they are usually founded on unwritten principles. Laws are interpreted by courts and tribunals. So a law is written, and then a court or tribunal will administer the law. They'll be the ones that actually tell you whether or not the law means this or that or the other and how it should be applied. Ethics are interpreted by individuals or professions. They're not necessarily anything to do with something that will be decided by courts. It's entirely up to the community to decide how ethics should be interpreted. And there'll be quite a bit of variation there, I can assure you. Laws are imposed on everybody equally, even though not all laws cover everybody, but they're imposed on everybody. And ethics are adopted by choice. And this is one of the choices you've made when you've decided to become a nurse, is that you've decided that you will take on the ethical structure of the nursing profession. Laws are enforceable by the police and the courts. As some of us know, particularly if you've had a speeding fine. But ethics are not strictly enforceable, but they can be subject to social expectations, and that can be quite a strong force. But they're not enforceable by the police and the courts. You won't go to jail for being unethical unless you're a solicitor. So, principal approaches we use for ethics in nursing, well, some good people have actually found a nice little way of looking at this so that we can simplify the way we approach ethics in nursing. And this lays out kind of a pattern, a kind of a cheat sheet that we can use when we come across ethical problems, and we've got a framework here that we can apply to those problems. So first of all, the principles we use: autonomy, and that is that nurses must respect the capacity of people to make decisions. And that's essential. So when we have a patient, we look after them. It's the patient that makes the decision about what happens to them, and we respect that. Even if it's not always the best thing for them, or we disagree with them, we respect their autonomy to make those decisions. Beneficence, which is the act to act in the best interest of others. And that means we put our own best interests to one side. Not our safety, of course, but we put our own best interest to one side, and we act in our patient's best interest. And that's a very important principle. Non-maleficence, we do no harm, another important principle. So whatever we do for the patient, even if it's something that they want us to do, we're restrained from doing it if we believe it will cause them harm. And justice, and that is that we must act equitably and accountably. So that is the final principle that wraps up all the others, because if we don't act and respect autonomy, if we don't act and show beneficence, if we don't act, or we do act, and we ignore non-maleficence, then we will be held accountable. And that's part of an ethical framework in a profession. Now, just so we can apply this a little bit, let's have a look at a scenario, and we'll try applying some of this principle framework to a scenario. Now, Sally, who's one of my favourite scenarios. Sally's an 80-year-old female, admitted confused and disorientated to hospital 5 days ago with uncontrolled type 2 diabetes. She's now stabilised on long-acting insulin, and she's for discharge today. Now, you're about to give Sally her insulin injection before her discharge. And when you do, Sally says, "No, I don't take insulin. I don't want that needle." Right? So, let's see if we can actually apply our framework to that particular problem, because this is a ticklish problem, one that you will come across in practice. So, let's see. First of all, autonomy. We should respect Sally's autonomy, shouldn't we? So when she says, "I don't take insulin, I don't want that needle," we must focus on that phrase, "I don't want that needle," and we must respect that. Okay? Now we must look at beneficence and apply that one. What happens when we look at beneficence in this situation? Well, we should act in Sally's best interest. Is it in her best interest that she doesn't have the insulin? Well, we know if she's got type 2 diabetes and she's sick enough with that to require insulin, she needs the insulin. And it's in her best interest to have it. So immediately we have a conflict, don't we, between the autonomy of Sally and between what's best for her that we should act for. Remembering, of course, that if we overrule her autonomy, that's not in her best interest either. Now, non-maleficence, do no harm. How does that apply here, Sally? Well, if we try to make Sally have that injection, is that going to cause her harm? Very likely. So I think we have to be very careful here. But if we don't give her the injection, will that cause her harm? Absolutely, because an omission of an act is equal to an act. So if we don't do something, we can equally cause harm as if we do. So we must also look at what we refrain from doing. So refraining from giving her the insulin will cause her harm. So that's also in conflict with one of our principles. And then we have to look at justice, to act equitably and accountably. Now, accountability here is the thing that I think really jumps up and looks me straight in the eye and says, hey, what's going on? If I'm going to be accountable, not just to Sally, but to the community in general, it's going to be expected here that I do something. Not that I simply say, whoa, too hard, can't be done. But the interesting thing is, it's very difficult to work out exactly what I should do when I apply each of the 4 principles. There is no solution here. I'm not going to give it to you. Really what this is a problem that presents you with a whole series of conflicts to think about. And that's going to be very interesting, because at the end of this series of 6 lectures, I'm going to ask you to consider Sally's position again. And I want you to think whether or not your opinion of what you should do has changed after hearing more about what your responsibilities and duties are as a registered nurse. So let's move on from our scenario. And now we're going to talk about laws, because ethics aren't laws and laws aren't ethics. But what are laws? They certainly do govern us, and they govern us quite severely. So let's have a look. First of all, law in Australia is based on a federation of states. Each state has sovereign powers, and the federation of states exists only because the states agree to it. And it agrees under a heading of a document called the Constitution of Australia. And that's what our Constitution does. It doesn't talk about the rights of individuals. It talks about the powers given by the states to the Commonwealth. And that's all it does. So Commonwealth law and state law exist side by side. And it's not always Commonwealth law that wins, and it's not always state law that wins. Usually the laws are about different things. Both laws apply to you. The powers of the Commonwealth are set out and limited by the Constitution. So if the Commonwealth law isn't founded in a power given to it in the Constitution, that law has no effect. But states have general powers to make laws for the peace and welfare and good government of the people. They have sovereign powers, so they don't need a constitution to support the basis of any law. They can make whatever laws they like because they have sovereignty. Commonwealth laws prevail over state laws only where there's an inconsistency. But if there's no inconsistency at all, then both laws will apply at the same time equally. But where there is an inconsistency, Commonwealth laws prevail. And laws vary between states. Now you've only got to look at the Crimes Act or even the Road Traffic Act to see that what is a crime in one state won't necessarily be a crime in another. And this forms a bit of a problem for us. And it's why for some particular forms of laws, we have Commonwealth laws that cover all of them. Now one of those in particular are the laws of marriage, where the states have given their powers over marriage to the Commonwealth because it just made sense to have the same law about marriage and de facto relationships over all of Australia. But otherwise, the laws will vary depending on which side of the line you're standing on the map. Now the Australian legal system gets a little bit more complicated than that because we just don't have Commonwealth laws and state laws. What we also have is a common law system. Now, what is the common law? Well, it's a system of laws and precedents that arose from a resolution of competing interests and rights. And it goes back to medieval England. And in medieval England, the king would say, okay, you're both here before me, two barons, you say that's your land, you say it's your land, I'll make a decision. And someone kept a record of all the decisions the king made over many, many years, and that became the common law. Now, the common law is based on that principle of defining competing rights between individuals, but it also means that if there isn't a law against something, it's okay to do it. Okay? So it means that the common law, that everything is all right to do unless there's a law restraining us from doing it. And that's how the common law works. We also have legislative laws, and these are laws that are made by the Parliament. When a Parliament votes and they pass an Act of Parliament, that is a law. And those laws will do things like govern the nursing professions, govern the medical professions, create new criminal laws, and create taxation laws, and do things like that. But they're legislative laws. They're voted on and made by the government by Acts of Parliament. And those two work together, the common law and legislative laws, to form all the laws of Australia. So just to make things a little bit easier, we'll also think about laws in another way. And that is that we also have a division between what we call criminal laws and civil laws. Okay? Now, criminal laws are usually by Acts of Parliament. They're to do with justice and punishment. They're the laws we make against crimes. This is behaviours that the state and the community recognise as being so obnoxious that we'll actually punish people if they do things like murder, manslaughter, assault, those kinds of things. The state, the Commonwealth, or the state governments are the ones that bring the action. Not one person against another. It's usually the police or the police prosecutor that brings the action against an individual. The action started by the police prosecutor. The defendant in the action, if you're considered as an accused person in a crime, is called the accused. The standard of proof they use most usually is beyond reasonable doubt. So you've got to be proven to really have done it, not just maybe have done it. And it's not just 50-50, 51%, oh, you're guilty. It's got to be really solid proof, beyond reasonable doubt, that you've done something before you'll be found guilty. And the outcome of any contest at law, where you're prosecuted for a crime, will usually end up in some kind of punishment, whether it's prison or a fine or a direction to attend some kind of behaviour modification, detoxification, all aimed at curbing behaviour and being able to rehabilitate people and make them more productive to integrate back into our society. That's criminal law. Now, there's also civil laws, and a lot of the civil laws are bound up in the common law, because civil law is mostly about competing interests between people. The common law, civil law is made up of common law and Acts of Parliament. Usually, the purpose of it is someone sues someone else to get compensation for some wrong that's been done, and it's brought by an individual or institution or a company against another individual, institution or a company. The plaintiff is the person who starts the action. The defendant is the one that defends the action. It's decided on the balance of probabilities, which means 51% is pretty convincing. And usually the outcome of it is you'll have some kind of damages awarded. And that's the primary outcome of civil law. So two very different sorts of law there, criminal law and civil law. So when we look at all our laws in that kind of context, we can see that ethics provides us with the framework of what we should do. Laws provides us with ethics that we must follow. Compulsions that mean that we have to do things or we must not do things. Laws also provide us with a framework in which we can settle competing interests, where people can go if they feel wronged and try to get damages from the person or the entity that's wronged them. So this is the basis of our laws in Australia. It's pretty complicated, but for the sake of nursing practice, what we have to concentrate on here is that, first of all, the same as in any other aspect of your life, you do not commit a criminal offence, and that's important. As well, in terms of civil law, You have to act in a way that is professional, doesn't involve negligence, where you breach the duty of care, and where you act also in a way that does someone no damage, that is wronged. And that's what the law means for nursing generally. Specifically, in terms of regulation, it means that if the state has regulated nursing, and the state has regulated all healthcare professions, you have to practice within the regulations that the state has imposed. And that's what we're going to talk about next in part 2 of this series, which is professional practice.